Mr. Irvin either doesn't speak the English language or is pretending not to speak the English language. When Secular Opinion in his introduction to the video made mockery of this particular individual in regards to the Kelly video, when he said, keep children away from this animal between the ages of 12 and 18, his response was, why are these people always talking about underage sex? They must be pedophiles. Well, the reference was to your specific instance where you were trying to get the naked pictures of an underage girl. I don't see how this would make Secular Opinion guilty of a crime that you've done, and him talking about it. The reference was obvious, and I would assume that you knew that, unless you're stupider than I think you are. I don't understand why you can't answer simple questions. After you were called lazy, you were called lazy by a specific YouTube user, and you said, I couldn't possibly be lazy. Look at how hard I've worked. I used to be skinny, and now I'm fat. Do you think this came easy? And the point you was trying to make is that you were lazy because you didn't have a job. So, regardless of to your physical attributes, the question coming up was why you refused to find gainful employment. And then by the same YouTube user brought up the question of your sense of entitlement for being, again, on the government dole and thinking that somehow you're entitled to this money, that this is yours. Your response was that, well, I never said that I was entitled. It's not really a matter of what you said. No one's arguing about the words that you have spoken. We're talking about your actions here and what you have done. Further, this YouTube user said that you like to be the martyr. Constantly, obviously referring to constantly your need to play the victim and always be calling out people because you're being persecuted personally. And your response was, I never told people to go out and do things. That's not really a response to the accusation that you're playing the martyr and the victim. It doesn't. I know that in your simple mind you only see martyrs in regards to Jesus, but believe it or not, she was calling you a martyr for how you constantly claim that you're the victim here. When you were called an elitist, your response was that you couldn't be an elitist because you were poor. So, are you pretending that you don't understand the word elitist, that in your little Illuminati world, the only people who can be elitist are the wealthy? You don't understand the simple concept of the word elitist, the belief that certain persons or members of certain classes or groups deserve favored treatment by virtue of their perceived superiority as an intellect, social status, or financial resources, that somehow you think that you are better than other people? You can only be that way if you are wealthy? You either don't understand the English language or you refuse to address any issues and like to play linguistic games as you dance around actual concepts, words, and logic itself. When you were called a dreg of society in reference to your not having any gainful employment, you incoherently responded with, well, I must be a drag on society because I believe in the founding fathers. That's a real issue for these people. No, you were being called a drag on society because you were stealing taxpayer monies. Of course, your response was, look, all these people care about is money, 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 money. Of course, you don't care about money, 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 because you don't work for money, money, money. You take everybody else's money, 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 and then you are upset with them for worrying about their taxpayer money, 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 money going to your pocket. Further in the paranoid delusions section of this video, in this claim about the founding fathers and some kind of sense of conservatism, I remember when you were upset that the quote-unquote trolls, an odd word for 50-something-odd man, for a 54-year-old man to use, if you are 54, however old you are, 50-some-odd-year-old man to use the word trolls and haters, when you said that the people on Facebook were gathering together to put a bill into legislation to remove welfare completely because of you. And if that were to happen, then you would be dead set against it because millions would die. This is a very, very conservative notion. Let's just ask people at the Cato Institute how they feel about this. Yes, conservatism indeed. But this is very strange that you would claim the founding fathers. I've made a previous video on your ridiculous notions of the founding fathers, and your claim of calling yourself a conservative, that you're bringing up your children to be conservatives, when actually they're being brought up to be little David Icks. There is no conservative from any realm, either a neoconservative, isolationists via Patrick J. Buchanan, the Ron Paul crowd, the Libertarian crowd, the Thomas Woodses, the Gutsmans, the Murray Rothbards, the Mark Levins, the take the whole list. The Edmund Burkes, the Russell Kirks, the William Crystal, Barry Goldwater, Ronald Reagan, the whole litany of the conservative movement from beginning to end. There is no one that would think that the federal government should come down and censor different people on YouTube. This is not a conservative notion. The entire idea is to remove federal power from the federal government because it's an overgrown leviathan. Of course, there's ridiculous arguments about it's self-defense. Still not a conservative notion to use the arm of the federal government to come down on censorship. And this is quite odd that you'd call yourself a conservative. Further, in a response to a YouTube user named Onision, to kind of prove your conservative and founding fathers' credentials, you picked on a child, basically, when it comes to the arguments of conservatism and what the founding stood for and didn't. You picked on Onision because you are a angry asshole cunt-like bully, is what you are. You are an asshole, is what you are. I would never make a response to Onision on constitutional grounds. I haven't yet. Why don't you pick on, I don't know, How the World Works, or The Young Turks, like I've done, or Alex Jones, like I've done, although you agree with Alex Jones more than you disagree with him. Although you disagree with The Young Turks, I don't know why you would never take them on. I have a 2-hour video, which I will take off of the private that I have on, in regards to our views on enhanced interrogation. You could take on, I don't know, Fringe Elements, or Raymond Dundas, or there's a whole list of YouTube users whose specialty is constitutionalism, not Onision, who's most famous for his bad marriages. But in your response to him, you said something along the lines of, not along the lines, you said, how dare he blaspheme the founders when the founders gave him his rights. They gave him his rights, they gave him his right to speak. This is an anathema against everything the founders believed in. The founders believed that man's rights were inalienable and came from God, and that man did not have a right to steal another man's rights, nor give him his rights, because it wasn't within man's power to give or take away rights. And if you're an atheist, to explain this simply, your rights are your own. They are not given or taken from other men, or men, in this case. And they use the term God to kind of explain this. And for you atheists, I don't mean this in a derogatory term, but to explain the idea of God as believed in by even people of today, and especially back then, is an infallible force, an unfuckable with-like force, the power, the wrath of the thunder, and the creator of the heavens and the earth, something that you do not fuck with, basically. So when they said your rights are inalienable and come from God, it doesn't matter whether you believe in this God or not, but understand the meaning, that your rights come from a force that is understood to be above all things, a creator of heaven and earth, a good, all-knowing, all-seeing being. You don't have to agree that the being exists, but understand the rationale that this is where your rights come from. Or, if you must believe that your rights are your own, that man cannot give or take away because it is not within man's power to give or take away your rights. I hope I've made this clear for those not of the faith and believing in things that are all-knowing and all-seeing. But Mr. von Helton, being the classic conservative, doesn't understand this simple concept and actually has the audacity to defend the founders to an obvious child and claim that, well, the founders gave you your rights. Founders didn't believe that they could give rights. Now, one of Onision's main points is a point that usually comes from the left or from the left sympathizers, and people who don't usually pay attention to this sort of thing, is that they're confused, and rightfully they should be, when they notice that the rhetoric of the time, the rhetoric of the founding fathers and the constitutional era and the Thomas Paines and the Freemen and the anti-federalist papers and the federalist papers and all the early constitutional writings, there's the strong rhetoric and language of liberty and of freedom and of private property, all within the time of slavery, all within when not only was there slavery, but that some of the founding fathers actually owned slaves. And they further argue, well, even back then, how can we return to when conservatives and Republicans claim that we should return to the founding era and the constitutional era, when in fact it was an era of slavery and debauchery? Why would we want to return to this kind of era? Further, blacks in America were referred to as 3/5 of an individual. This is not an era that I would want to return to, where man was considered 3/5 of a human being. Now, there is technically a conservative response, and you can agree with the position or not. But as a caveat and as a note, we, on this side of the aisle, conservatives, not whatever Mr. Helton is supposed to be, but we actually believe that the document, the founding document, set out certain enumerated principles of power, where it delegated certain powers to the three different separated branches of government to be shared. It specifically says which powers go to which branch of government, to the judiciary, to the legislative, the executive, specifically, so that nobody can accumulate too much power in one branch. These ideas and notions are safe and are timeless, if you can believe that. And there even is an amendment process. I mean, if you want to, you can always use the amendment process to change the Constitution. The problem comes when you don't use the amendment process and try to abuse the system in the courts to get whatever it is that you want done. But more on that perhaps in a different video. But the main point is that we believe that within these founding principles, it's not a perfect document, there's nothing is, but generally, if followed, the ideas of liberty and freedom will be maintained. And that those voices who call for a breakaway from this document are actually voices who merely seek to increase the size of the federal government and to increase the size and the power of the federal government, or maybe even the state's government, depending on what they're arguing for, when states' rights interfere with individual rights. Now, the excuses and the reasons that they use are arguments about racism, but there are answers to these questions as to why that is. But again, just a small note is that we believe that people who are bashing the document are merely trying to grow government power. Just saying. That we believe that that is the real motivation for bashing the document. But the question is, how is it that the founders can speak of liberty and democracy and yet live in a time of slavery and some even own slaves? Now, the real response, unlike Mr. von Helton, is not to whitewash history and to remake history when he claimed that slavery never existed under the founders and it only existed after they died. And that slaves were being paid a half a penny a day, and there was no slavery under the time of the founders. This would be very strange, because the actual response to the questions asked about this conflict is this: that during the ratification debates, there was an argument between the southern states and pretty much everybody else over what to do about the issue of slavery. And the compromise that was reached is that they decided to keep slavery in order for the Constitution to be ratified. Now, language within the Constitution itself would eventually doom slavery as an institution, as Lincoln used the document, rightfully or wrongfully, as some people may argue, and its language of liberty to actually eventually lead to emancipation. Again, it's not an argument with the Civil War and what it was about, but the document itself. If the document had not been ratified, if that compromise had not been made, slavery would have lasted much longer. Because the end of slavery, the Civil War, would never have come. Because the states would not have been, they would never have been together enough under the ratified Constitution for them to have a civil war. There would have been separate confederated states. So the answer is that this compromise was made with this Dark Constitution, with the southern states, keeping the language of liberty within the document, which would eventually have to lead to this dissolving of the Dark Constitution at some point, and which eventually did. It led to the Civil War, and the Civil War would have happened if the Constitution had not been ratified. Again, despite Mr. Irvin's fanciful notions and whitewashing of history that slavery simply didn't exist, I wonder then what the argument in, I believe it was, in August 21st through August 22nd, 1787, what the debates, the ratification at the Philadelphia Convention, the Constitutional Convention, what this debate was over. It was over servitude and paying somebody $1 a day. There was an argument over slavery at the convention. How could slavery not have existed if they were arguing between each other over slavery itself? Let's go through the record. Mr. Luther Martin proposed to vary Article 7, Section 4, so as to allow a prohibition or tax on the importation of slaves. In the first place, as 5 slaves were to be counted as 3 freemen, in the appointment of representatives, such a clause would leave an encouragement to this traffic. In the second place, slaves weakened one part of the Union, which the other parts were bound to protect. The privilege of importing them was therefore unreasonable. And in the third place, it was inconsistent with the principles of the Revolution and dishonorable to the American character to have such a feature in the Constitution. Mr. John Rutledge, South Carolina, did not see how the importation of slaves could be encouraged by this section. He was not apprehensive of insurrections and would readily exempt the other states from the obligations to protect the Southern against them. Religion and humanity had nothing to do with the question. Interest alone and the governing principle with nations. The true question at present is whether the Southern states shall or shall not be parties to the Union. If the Northern states consult their interests, they will not oppose the increase of slaves, which will increase the commodities of which they become the carriers. Mr. Oliver Ellsworth was for leaving the clause as it stands. Let every state import what it pleases. The morality or wisdom of slavery are considerations belonging to the states themselves, while the richest part enriches the whole, and the states are the best judges for their particular interest. The old Confederation had not meddled with this point, and he did not see any greater necessity for bringing it within the policy of the new one. Mr. Charles Pickney of South Carolina. South Carolina can never receive the plan if it prohibits the slave trade. In every proposed extension of the powers of Congress, the state has expressly and watchfully expected that of meddling with the importation of Negroes. If the states be all left at liberty on this subject, South Carolina may perhaps by degrees do of herself what is wished, as Virginia and Maryland already have done. Mr. Roger Sherman was for leaving the clause as it stands. He disapproved of the slave trade, yet as the states were now possessed of the right to import slaves, as the public good did not require to be taken from them, and as it was expedient to have a few objections as possible to the proposed scheme of government, he thought it best to leave the matter as we find it. He observed that the abolition of slavery seemed to be going on in the United States, and that the good sense of the several states would probably by degrees completed. He urged on the convention the necessity of dispatching its business. Colonel George Mason of Virginia. This infernal traffic originated in the avarice of British merchants. The British government constantly checked the attempts of Virginia to put a stop to it. The present question concerns not the importating states alone, but the whole Union. The evil of having slaves was experiencing during the late war. Had slaves been treated as they might have been by the enemy, they would have proved dangerous instruments in their hands. But their folly dealt with the slaves as it did by the Tories. He mentioned the dangerous insurrections of the slaves in Greece and Sicily, and the insurrections given by Cromwell to the commissioners sent to Virginia to arm the servants and slaves in case other means of obtaining its submission should fail. Maryland and Virginia, he said, had already prohibited the importation of slaves expressly. North Carolina had done the same in substance. All this would be in vain if South Carolina and Georgia be at liberty to import. The Western people are already calling out for slaves for their new lands, and will fill that country with slaves if they can be got through South Carolina and Georgia. Slavery discourages arts and manufactures. The poor despise labor when performed by slaves. They prevent the immigration of whites, who really enrich and strengthen a country. They produce the most pernicious effects on manners. Every master of slaves is born a petty tyrant. They bring the judgment of heaven on a country. As nations cannot be rewarded or punished in the next world, they must be in this. By an inevitable chain, cause and effect, Providence punishes national sins by national calamities. He lamented that some of our Eastern brethren had, from a lust of gain, embarked on this nefarious traffic. As to the state being in a possession of a right to import, this was the cause, with many other rights, now to be properly given up. He held it essential, in every point of view, that the general government should have power to prevent the increase of slavery. Again, Mr. Irvin, there was an argument over slavery at the convention. So it did exist, obviously. You can agree with these particular individuals or not on their specific positions, but the argument did occur. Mr. Oliver Ellsworth, as he had never owned a slave, could not judge the effects of slavery on character. He said, however, that if it was to be considered in a moral light, we ought to go further and free those already in the country. As slaves also multiply so fast in Virginia and Maryland that it is cheaper to raise them than import them. Whilst in the sickly rice swamps foreign supplies are necessary, if we go no further than is urged, we shall be unjust towards South Carolina and Georgia. Let us not intermeddle. As population increases, poor laborers will be plenty, so as to render slaves useless. Slavery in time will not be a speck in our country. Provision is already made in Connecticut for abolishing it, and the abolition has already taken place in Massachusetts. As to the danger of insurrections from foreign influence, that will become a motive of too kind treatment of the slaves. Mr. Charles Pickney of South Carolina. If slavery be wrong, it is justified by the example of all the world. He cited the case of Greece, Rome, and the other ancient states, the sanction given by France, England, Holland, and other modern states. In all ages, one half of mankind... Look, I pronounced it France. It's France. I'm from America. It's not France. All ages, one half of mankind have been slaves. If the southern states were let alone, they will probably of themselves stop importations. He would himself, as a citizen of South Carolina, vote for it. An attempt to take away the right as proposed would produce serious objections to the Constitution which he wished to see adopted. General Charles Pickney of South Carolina declared it to be his firm opinion that if himself and all his colleagues were to sign the Constitution and use their personal influence, it would be of no avail towards obtaining the assent of their constituents. South Carolina and Georgia cannot do without slaves. As to Virginia, she will gain by stopping the importations. Her slaves will rise in value, and she has more than she wants. It would be unequal to require South Carolina and Georgia to confederate on such unequal terms. Mr. Irvin is obviously a moron, because this argument is actually taking place about the situation and the cause and the rights of states and slavery. He said the royal assent before the Revolution had never been refused to South Carolina as to Virginia. He contended that the importation of slaves would be for the interest of the whole Union. The more slaves, the more produce to employ the carrying trade, the more consumption also, and the more of this, the more revenue for the common treasury. He admitted it to be reasonable that slaves should be dutied like other imports, but should consider rejection of the clause as an exclusion of South Carolina from the Union. Mr. Abram Baldwin had conceived national objects alone to be before the convention. No such as, like the present, where the local nature, Georgia was decided on this point. That state had always hitherto supposed the general government to be the pursuit of the central states, who wished to have a vortex for everything, that her distance would preclude her from equal advantage, and that she could not prudently purchase it by yielding national powers. From this it might be understood in what light she would view in an attempt to abridge one of the favorite prerogatives. If left to herself, she may probably put a stop to the evil. As one ground for this conjecture, he took notice of the sect of which he said was a respectable class of people who carried their ethics beyond the mere equality of men, extending their humanity to the claims of the whole animal creation. Mr. James Wilson of Philadelphia observed that if South Carolina and Georgia were themselves disposed to get rid of the importation of slaves in a short time, as had been suggested, they would never refuse to unite because of the importation might be prohibited. As the section now stands, all articles imported are to be taxed. Slaves alone are exempt. This is, in fact, a bounty on that article. Mr. Eldridge Gerry of Massachusetts thought we had nothing to do with the conduct of the states as to slaves, but ought to be careful not to give any sanction to it. Mr. John Dickinson considered it an inadmissible on every principle of honor and safety that the importation of slaves should be authorized to the states by the Constitution. The true question was whether the national happiness would be promoted or impeded by the importation, and this question ought to be left to the national government, not to the states particularly interested. If England and France permit slavery, slaves are at the same time excluded from both those kingdoms. Greece and Rome were made unhappy by their slaves. He could not believe that the southern states would refuse to confederate on the account apprehended, especially as the power was not likely to be immediately exercised by the general government. Mr. H. Williamson from North Carolina stated the law of North Carolina on the subject, to wit, that it did not directly prohibit the importation of slaves, and imposed a duty of £5 on each slave imported from Africa, £10 on each from elsewhere, and £50 on each from a state licensing manumission. He thought the southern states could not be members of the Union if the clause be rejected, and that it is wrong to force anything down not absolutely necessary, and which any state must disagree to. Mr. Rufus King of Massachusetts thought the subject would be considered in the political light only. If two states will not agree to the Constitution as stated on one side, he could affirm with equal belief on the other that the great and equal opposition would be experienced from other states. He remarked that the exemption of slaves from duty, whilst every other import was subjected to it, as an inequality that could not fail to strike the commercial sagacity of the northern and middle states. Speak English! Mr. John Lonergan of New Hampshire was strenuous for giving the power to the general government. He could not with good conscience leave it with the states. who could then go on with the traffic without being restrained by the opinions here given, and they will themselves cease to import slaves. General Charles C. Pickens of South Carolina thought himself bound to declare candidly that he did not think South Carolina would stop her importations of slaves in any short time, but only stop them occasionally, as she now does. He moved to commit the clause that slaves might be made liable to an equal tax with other imports, which he thought right, and which would remove one difficulty that had been started. Mr. John Rutledge of South Carolina. If the convention thinks that North Carolina, South Carolina, and Georgia will ever agree to the plan unless the right to import slaves were untouched, the expectation is in vain. The people of those states will never be such fools as to give up an important interest. He was strenuous against striking out this section and seconded the motion of General Pickens for a commitment. Mr. Gouverneur Morris from PA wishes the whole subject to be committed, including the clauses relating to taxes on exports and Navigation Act. These things may from a bargaining among the northern and southern states. Mr. Pierce Butler, South Carolina, declared that he never would agree to the power of taxing exports. Mr. Roger Sherman said that it would be better to let southern states import slaves than to part with them if they made that the only issue. He was opposed to a tax on slaves imported and making the matters worse because it implied they were property. He acknowledged that if the power prohibiting the importation to the general government, it would be exercised. He thought it would be its duty to exercise the power. Mr. George Reed was for the committed, provided the clause concerning taxes on exports should also be committed. Mr. Roger Sherman observed that the clause had been agreed to and therefore could not be committed. Mr. Edmund Randolph of Virginia was for committing an order that some middle ground might, if possible, be found. He could never agree to the clause as it stands. He would sooner risk the Constitution. He dwelt on the dilemma to which the convention was exposed. By agreeing to the clause, it would revolt the Quakers, the Methodists, and many others in the states having no slaves. On the other hand, 2 states might be lost to the Union. Let us then, he said, try the chance of commitment. By lost to the Union, he means that the Union would lose them. On the question for committing the remaining part of the sections 4 and 5 of Article 7, Connecticut, New Jersey, Maryland, Virginia, North Carolina, South Carolina, Georgia, I-7, New Hampshire, Pennsylvania, Delaware, numbers 3, Massachusetts, absented by not voting. So this argument in regards to slavery in the time of the founding actually did take place. And slavery did exist under the founders, and the words slavery and servant were not exchangeable. They were not talking about the servant and the state's right to have servants and to tax the importation of servants. It was slavery. There's no need to whitewash history. One can defend the founders on its own grounds. Stupid. In regards to the 3/5 clause, it is important to remember what the history of the 3/5 clause is. It was actually the anti-slavery voices and, shall we say, crowd that wanted the 3/5 clause to be put in. See, the southern states wanted to have more legislative power, and they wanted to count their slaves as votes because it was done by population, right? Depending on how many were in the population was the amount of representatives you got to send to the state legislature or to D.C., depending on how the power was separated. Don't remember it off the top of my head at this moment. I'm not Mr. Von Helton. I'm not going to claim to know everything and make shit up as I go along. But the idea is that they would have had more power within the government via representation if they were able to count their slaves. And the anti-slavery state said, absolutely not. You're not going to count people who you're treating like garbage, you're using slave labor, and you're not going to count them and get more power within the government simply because they're there and there are people that happen to be on your farm. So they compromised with the 3/5 clause, meaning that slaves would only be counted 3/5 of an individual. This was done specifically. 3/5 compromise was a compromise between southern and northern states reached during the Philadelphia Convention of 1787. This goes to further Mr. Von Helton's notions that there was no slaves. If there was no slaves, then what is the 3/5 compromise of 1787 during the time of the founders? I thought there were no slaves. It was the 3/5 compromise in servitude. In 1787, in which 3/5 of the enumerated population of slaves would be counted for representation purposes regarding both the distribution of taxes and apportionment of the members of the United States House of Representatives. It was proposed by delegates James Wilson and Roger Sherman. Delegates opposed to slavery generally wished the court to only count 3/5 inhabitants of each state, but delegates supporters of slavery, on the other hand, generally wanted to count slaves in their actual numbers. Since slaves could not vote, slaveholders would thus have the benefit of increased representation in the House and and the Electoral College. In the final compromise of counting all other persons as only 3/5 of their actual numbers reduced the power of the slave states relative to the original southern proposals, but it increased it over the northern position. The 3/5 compromise is found in Article 1, Section 2, Paragraph 3 of the United States Constitution, which Mr. von Helton claims to know and defend so well. Of further note, specifically in regards to Thomas Jefferson, is the original draft of the Declaration included a lambasting with visceral language against the King of England for the slave trade as brought to the United States. It was eventually removed on the protestations of the pro-slavery states, but the original language said this: "He, the King of Britain, has waged cruel war against human nature itself, violating its most sacred rights of life and liberty in the persons of a distant people who never offended him, captivating and carrying them into slavery in another hemisphere, or to incur miserable death in their transportation thither. This piratical warfare, this opprobrium of infidel powers, is the warfare of the Christian King of Great Britain. Determined to keep open a market where men should be bought and sold, he has prostituted his negative for suppressing every legislative attempt to prohibit or to restrain this execrable commerce, and that this assemblage of horrors might want no fact of distinguished dye. He is now exciting those very people to rise in arms among us, and to purchase that liberty for which he has deprived them, by murdering the people upon whom he also obtruded them, thus paying off former crimes committed against the liberties of one people with crimes which he urges them to commit against the lives of another." So again, the real defense is actually the exact opposite of what von Helton said. Von Helton said that there was no slavery. That's complete and utter bullshit. He probably pulled it from somewhere, and if he ever responds, he'll respond with his bullshit-like claim. The other thing that Mr. Helton said, which I can address immediately, was the notion that D.C. was created by the Illuminati. Good God. Now, Illuminatans are not generally considered conservatives by conservatives. They're actually considered a drag on the party and the movement. But the reason how the capital actually ended up moving to D.C., I know this is not a very funny video, but bear with me, was because originally the D.C. was, well, it was in Philadelphia, and then at the point of when it moved to D.C. was in New York. And the argument between Alexander Hamilton and Thomas Jefferson, a famous argument in regards to government, Alexander Hamilton being the consummate federalist, wanting to constantly increase the size of the federal government, Thomas Jefferson constantly trying to revert back to within the confines of the Constitution as written, and Alexander Hamilton abusing it. A fantastic book on this issue, if ever. And if individuals say that they want it, I will put up my audio version. I've read the entire book into an audio book, but nobody watched it. It's currently on private on my channel. If you want to listen to it, it's me reading it. I've edited out all the ums and coughs in the middle, but you don't even have to read it. It could be on YouTube. You're free to download it, transfer it to an MP3, put it in your car, put it on your iPhones, and you can listen to a book that I've read over 30 times. Now, mind you, I don't agree with everything in this book. I'm not a sponge, I'm a filter. But it is an extremely important book on American history. It's called Hamilton's Curse by Thomas J. DiLorenzo. And not a lot of people agree with Mr. DiLorenzo, and even historians from his side of the aisle don't agree with him on everything, as I don't either. But what it adds to historical context cannot be pushed aside. It is absolutely essential reading. I've read it over 30 times. Fantastic writing. Yes, so it was Alexander Hamilton who constantly tried to increase the size of the federal government, Thomas Jefferson who tried to keep it within the confines of the Constitution. Mr. Alexander Hamilton wanted to have a national bank. Thomas Jefferson did not. Mr. Alexander Hamilton wanted to keep the capital in New York near the moneyed interests. Thomas Jefferson wanted to move the capital out of New York, away from the moneyed interests of, if there was a Wall Street there at the time, but away from the economic center of the New World. Not the New World Order, but the New World, which was, right on the coast, and the ocean, the Atlantic Ocean, the city on the port that served as the commerce center of the New World, not the New World Order, whatever. So the compromise was this. Alexander Hamilton would get his bank, but the capital would be removed from the Hudson River and moved to the Potomac. The mosquito-filled, middle of nowhere Potomac, which is known as the Washington, D.C. area. And this was done because Thomas Jefferson wanted the capital away from the moneyed interests of the city of New York and the state of New York and the capital of economic activity. How, for the love of God, would the Illuminati want to move the capital of the United States away from the moneyed interests of New York and to the Potomac? What purpose would it serve? And please, the babble and the historical garbage that is going to come if he ever responds to this will be amazing. I love any time he talks about the founders of the Constitution because of his inherently getting it wrong. And then further, he made some claims about abortion. Now, as a great philosopher king once told me in private, Mr. Helton kind of gets his ideas from like the back of a book. You know how it's kind of summarized and you just read the little bullets on the back. This is where he gets his ideas from. So he may come to certain conclusions that may sound familiar to you, but he obviously has no real grasp of the issue. He may get to C, but he has no idea what B is, and it's kind of based in A. So it's A, question mark, and then C. This comes to most of the subjects that he talks about, be it Islam, be it the death penalty, be it abortion even. He just doesn't have a real grasp of the issue. And in his when he talked about abortion, he said that abortion, or Roe v. Wade more specifically, I guess would be the deal, because this is the case that made it legal, and this is without even referencing the case. He said when the court acted as if they were legislating from the bench, which they were, but he says that because everybody has a right to life, liberty, and pursuit of happiness, and one can't have those if they are dead. Of course, accepting the notion that life begins in conception immediately, right off the bat, as if this is an inarguable offense, is that since you're alive, and you can't have rights, if you can't have the right to life, liberty, and happiness if you are dead, well then obviously you can't have abortion. I'm just going to magically assume that life begins at conception. Is he going to pretend that that's not what he did? Further, that's not really the argument here. The argument isn't whether you believe life begins at conception. The argument is over Roe v. Wade as a constitutional matter. Now, regardless of where you stand on abortion, women's rights, and where life begins, the problem with Roe v. Wade is that it was passed in a very questionable, unconstitutional manner. At the very least, it should have been left up to the states and not to the federal government. Again, this doesn't matter where you believe that life begins at conception. And the point is, and let me lay down some conservative law for you here, ladies and gentlemen, is that we believe that the system, as it is set up and designed, works in a certain fashion. There is an amendment process. If you want to add a law, you can. It's a legal way of doing things. The problem then becomes when certain individuals, via ideology, realize that they are trying to pass something that most people don't want, or is controversial, something like abortion. So what they do is they abuse the court in order to get this done constitutionally, kind of through the back door. Now, whether you agree with the abortion issue, the bigger problem is abusing the system. And what people never seem to understand is that if you allow abuses of the system that is already designed for room enough for change, there's no need to do it, but you realize that your ideology or your position is not popular, and that you can't get 2/3 of a vote, so therefore you try to abuse the court system, is that you're not always going to remain in power. At some point, your ideological opposition will be in power, and if you use this abuse of power, if you've opened up the door to allow abuses of power and to abuse the system, all you're going to do at the end of the day is hurt yourself. This is the problem with tyranny. Tyranny cannot be allowed to flourish, and statism cannot be allowed to flourish, regardless of which side of the aisle it comes from. You cannot leave the door open this way, and people never seem to understand this. They seem to think that they will be in power. So if we are allowing the courts to be the final arbiter of what is and what isn't constitutional, which is legal, but we don't want to use the legislative process and actually pass laws in regards to abortion, gay marriage, or whatever other controversial social issues that exist and that are the base of a lot of the left's positions. If you're going to abuse the power, you are abuse the system. You are going to be the victim of the very same system that you have now abused, because now you have allowed this to happen. And this is never a good idea. And these are concepts that are completely lost on Mr. Von Helton, because he has no problem using the federal government to clamp down on censorship. Of course, we now have Barack Obama as president of the United States. The man disagrees, supposedly, with Barack Obama, the president of the United States, and yet he's still willing to give over the power to the federal government to allow censorship on the internet. This is an amazing conflict, which he just seems to ignore. That, he'll give the power to the federal government, and yet the executive of the federal government is a man he extremely distrusts and doesn't like for all the wrong reasons. But he's still willing to give over this power, not understanding. If this were a Bush administration, I could kind of understand his argument. He's like, well, I don't know how much he agreed with the former president on things, but if it was a president that he agreed with, you could kind of see him making this mistake. But currently, the chief executive, the CINC, the commander-in-chief, the CINC, commander-in-chief, CIC, excuse me, is a person that he doesn't trust. So why he would want to give that much power to the federal government is beyond me. But the real issue, the abortion issue, was never about conception. Getting back to, I was just talking about the system as a whole and why it needs to be maintained and why I don't like to see abuses of said system, because it just opens the door for all kinds of tyranny. So regardless of my views, my personal views on where life begins, I find Roe versus Wade unconstitutional in the manner that it was passed, and at the very least should have been left to the states. Again, this is regardless of my personal positions on abortion. I don't know if many people can grasp this concept that you can remove yourself from your personal beliefs on an issue and realize that in the manner of which a bill was passed is not healthy for the system at large. So the abortion issue really came down to was a lot about the right of privacy. Never, as far as my understanding, was the argument in Roe v. Wade, the fact that there was life and liberty and the pursuit of happiness and the assumption and the belief that life begins at conception and therefore life, liberty, and the pursuit of happiness is in conflict with the right to abort. That's not what happened. Was not the argument, never was the argument, as far as I can understand. But Mr. Helton, all he knows is that he's supposed to defend the founders, so he makes up some nonsense about the founders. All he knows is that he's supposed to be on a certain side of abortion, so he comes out on this side. But does he have an actual grasping and understanding of the issue? No. Because the actual issues in Roe v. Wade were
death by privacy. Our nationwide policy of abortion on demand through all 9 months of pregnancy was neither voted for by our people nor enacted by our legislators. Not a single state had such unrestricted abortion before the Supreme Court decreed it to be national policy in 1973. Ronald Reagan, 1983. Today, legalized abortion is the law of the land because the Supreme Court decided in 1973 that its recently created constitutional right to privacy also included a new constitutional right to abortion. If you look in the Constitution, however, you will find no general right to privacy any more than you will find a right to abortion, and for good reason. It's not there. The framers assumed no general right to privacy because, to state the obvious, criminal and evil acts can be committed in privacy. Criminal codes are full of such examples, from murder to incest to rape and other crimes. How judges make law. The modern argument for a right to privacy began in 1961 in Justice John Marshall Harlan's dissent in Poe v. Ullman. The case was brought by Planned Parenthood on behalf of a carefully selected group of people, a married couple, a single woman, and a Planned Parenthood obstetrician, C. Lee Buxton. Planned Parenthood's suit was directed against a Connecticut law that prohibited the sale and use of contraceptives. The Supreme Court dismissed the case because the law had not been enforced against the people in Planned Parenthood's case. It is a basic judicial principle that there has to be an actual legal dispute to be adjudicated. But Justice Harlan issued a dissent, writing, "I believe that a statute making it a criminal offense for married couples to use contraceptives is an intolerable and unjustifiable invasion of privacy in the conduct of the most intimate concerns of an individual's personal life." Harlan provided an extensive rationale for his position, which became the theoretical cornerstone for the right to privacy. Where did Harlan derive his notions about privacy rights? Melvin L. Wolfe, a lawyer for the American Civil Liberties Union, claims credit for first raising the idea with Harlan in the ACLU's Friend of the Court brief in Poe v. Ullman. Wolfe later explained his strategy for getting the court to adopt the privacy rights approach. Judges dislike breaking entirely new ground. If they are considering adopting a novel principle, they prefer to rest their decision on earlier law if they can, and to show that the present case involves merely an incremental change, not a wholesale break with the past. Constitutional litigators are forever trying to persuade courts that the result they are seeking would be just a short step from some other case whose decision rests soundly on ancient precedent. Since the issue of sexual privacy had not been raised in any earlier case, we employed the familiar technique of argument by analogy. If there is no exact counterpart to the particular case before the court, there are others that resemble it in a general sort of way, and the principles applied in the similar cases should also be applied, perhaps even extended a little bit, to the new case. In other words, Wolfe understood that the court would be open to rewriting the Constitution by pretending to uphold it. Although Harlan's was a minority opinion and had no immediate legal effect, its impact would soon become clear. After Poe was decided, Planned Parenthood officials found a way to get arrested so they could mount another challenge to Connecticut law. In 1965, Justice William O. Douglas adopted Harlan's reasoning in the majority opinion in the case of Griswold v. Connecticut, and the right to privacy became constitutional law. Douglas, who was appointed by President Franklin Roosevelt in 1939, is most famous for being the longest-serving justice, and, to conservatives, for writing one of the most parodied phrases in Supreme Court history. In order to strike down the Connecticut law prohibiting the sale of contraceptives, Douglas wrote that specific guarantees in the Bill of Rights have penumbras formed by emanations from those guarantees that help give them life and substance. Don't be embarrassed if you don't know what emanations from penumbras are. Young lawyers across America had to pull out their dictionaries when reading Griswold for the first time. A penumbra is an astronomical term describing the partial shadow in an eclipse or the edge of a sunspot, and it is another way to describe something unclear or uncertain. Emanation is a scientific term for gas made from radioactive decay. It also means an emission. Douglas's decision not only found a right to privacy in a penumbra of an emanation, it manipulated the facts of the case. Estelle Griswold, the executive director of the Planned Parenthood League of Connecticut, and Dr. C. Lee Buxton, the group's medical director, gave information and prescribed birth control to a married couple. Griswold and Buxton, not the married couple, were later convicted and fined $100 each. The relationship at issue, then, was doctor-patient, not husband-wife. Yet Douglas framed his opinion around a presumed right to marital privacy. He expounded at length about the sanctity of marriage, but used vague phrasing to describe the rights at issue, never explicitly stating that married couples have a right to use contraceptives. He even raised the ugly specter of sex police, though no police had intruded into anyone's bedroom. Would we allow the police to search the sacred precincts of marital bedrooms for telltale signs of the use of contraceptives? This little phrase has been used as holy writ by judicial activists ever since, to further expand the right to privacy in a variety of areas, including abortion and sodomy, as we'll see. Justice Hugo Black, in his dissent, was not impressed. He attacked the way Douglas had turned constitutional law into semantics by replacing the language of actual rights with the phrase right to privacy. He wrote, The court talks about a constitutional right of privacy, as though there is some constitutional provision or provisions forbidding any law ever to be passed which might abridge the privacy of individuals. But there is not. There are, of course, guarantees in certain specific constitutional provisions which are designed in part to protect privacy at certain times and places with respect to certain activities. Black, normally an ally of Douglas, feared that using such a phrase as right to privacy could be a double-edged sword. One of the most effective ways of diluting or expanding a constitutionally guaranteed right is to substitute for the crucial word or words of a constitutional guarantee another word or words, more or less flexible and more or less restricted in meaning. Privacy is a broad, abstract, and ambiguous concept, which can easily be shrunken in meaning, but which can also, on the other hand, easily be interpreted as a constitutional ban against many things other than searches and seizures. Black concluded by saying, "I like my privacy as well as the next one, but I am nevertheless compelled to admit that government has a right to invade it, unless prohibited by some specific constitutional provision." 7 years after the issue of married couples and contraceptives was decided in Griswold, the court considered contraceptives and unmarried couples in 1972 in Eisenstadt versus Baird. Although he quoted Griswold frequently in the majority opinion, Justice William Brennan nonetheless found that Massachusetts law could be overturned on 14th Amendment equal protection grounds without having to rely on the marital privacy rights created by Griswold. While Connecticut's law in Griswold prohibited the use of contraceptives, Massachusetts had laws restricting their distribution. Married people could obtain contraceptives only from doctors or pharmacists by prescription, while single people could obtain them only to prevent the spread of disease. Massachusetts law was challenged when William Baird gave a speech at Boston University about birth control and overpopulation. He exhibited contraceptives and gave vaginal foam to a young woman in the audience, both of which actions were illegal, and Baird was convicted. His conviction for showing contraceptives was overturned by the Massachusetts Supreme Judicial Court on First Amendment grounds, so distribution was the sole issue before the U.S. Supreme Court. Brennan found that the statute was a prohibition on contraception per se, and ruled that whatever the rights of the individual to access contraceptives may be, the rights must be the same for the unmarried and the married alike. Yet again, a major Supreme Court decision rested on a naked assertion of opinion instead of legal reasoning. Nowhere does the Constitution require that married couples and single people be treated the same where contraception is involved. Brennan then argued for expanding the right to privacy. If under Griswold the distribution of contraceptives to married persons cannot be prohibited, a ban on distribution to unmarried persons would be equally impermissible. It is true that in Griswold the right of privacy in question inhered in the marital relationship. Yet the marital couple is not an independent entity with a mind and heart of its own, but an association of two individuals, each with a separate intellectual and emotional makeup. In other words, Douglas's rhetoric about the sanctity of marriage was essentially irrelevant. The right to privacy belonged to individuals, not the couple. Brennan continued, "If the right of privacy means anything, it is the right of the individual, married or single, to be free from unwarranted governmental intrusion into matters so fundamentally affecting a person as the decision whether to bear or beget a child." So the right to privacy means everything and nothing. It has no constitutional basis and no tangible form. But what is clear is that the Supreme Court, by usurping the legislature's authority to set social policy, has seized from the people the power to make such determinations. A mere 5 justices are now able to substitute their personal judgments for those of Congress and every state government in the name of privacy rights. This quiet revolution against representative government has gone largely unnoticed. The exception is the occasional court decision on hot-button issues, in which the attention is mostly on the court's ruling, not on its abuse of power. Also notice how Brennan inserted the phrase, to bear or beget a child, in the opinion. The case was about contraceptives, which affect only the begetting of children. Yet Brennan explicitly added the concept of bearing a child as well. He was subtly laying the foundation to extend the right of privacy to encompass the right to abortion. This occurred at a time when Roe v. Wade, a case involving abortion, had twice been argued before the court, but had not yet been decided. Notice how the judicial activists work. Inserting a word in a majority opinion here and there, inserting a phrase in a dissenting opinion, all the while biding their time until 5 justices can be convinced to join the cause. The facts of Roe are straightforward. Roe, the pseudonym for Norma McCorvey, a pregnant woman from Texas, could not legally obtain an abortion in Texas, where it was a crime to procure an abortion or to attempt to perform an abortion, except by medical advice for the purpose of saving the life of the mother. The central issue was whether Roe had a right to abort her baby, although her life was not at risk. Roe provides an opportunity to explore how external influences, as well as a justice's personal foibles and prejudices, contribute to judicial activism. Justice Harry Blackmun, who wrote the majority opinion, was nominated by President Richard Nixon in 1970 as a judicial conservative. Indeed, one of Nixon's campaign issues in 1968 was the liberalism of the Supreme Court under Chief Justice Earl Warren. What particularly annoyed Nixon and other Republicans was that some of the court's staunchest liberals, Justices Earl Warren and William Brennan among them, had been nominated by President Dwight Eisenhower, a Republican. Nixon thought the court was a disaster, filled with senile old bastards and fools. He was disgusted at how Justice Potter Stewart, another Eisenhower appointee, had been overwhelmed by the Washington-Georgetown social set and had turned out to be weak and dumb. Nixon wanted to make sure he appointed justices to the Supreme Court who believed in following the original intent of the Constitution. He replaced the retiring Earl Warren with Warren Burger of Minnesota. Filling Justice Abe Fortas's seat was more difficult. The Senate rejected Nixon's first 2 nominees, Clement Haynsworth of South Carolina and Harold Carswell of Florida. Nixon abandoned his attempts to name a Southerner to the court and considered Blackmun, another Minnesotan, who was a judge on the 8th Circuit Court of Appeals and former counsel to the prestigious Mayo Clinic. As Nixon's third choice, Blackmun later called himself Old Number 3. Assistant Attorney General William Rehnquist vetted Blackmun and found him competent but not exceptional. Blackmun was called to Washington and met with Nixon by the Rose Garden window. So I went over, and we looked out, and he asked a couple of questions, among which, I'll never forget this. He said, "What kind of a woman is Mrs. Blackmun?" And I said, "What do you mean?" He said, "She will be wooed by the Georgetown crowd. Can she withstand that kind of wooing?" I said, "I thought she could." Blackmun and others sneered at Nixon for asking questions about his wife. Yet Nixon was quite insightful about how conservatives are continually seduced by the liberal establishment once they move inside the Beltway. They grow or evolve in office, meaning they become receptive to the liberal elitism of the establishment. Nixon was soon able to put 2 more justices on the court after Blackmun, William Rehnquist and Democrat Lewis Powell. During his first full term on the court, Blackmun voted with Burger 89% of the time. Blackmun and Burger, who had been close friends in childhood, were called the Minnesota Twins. Blackmun resented the nickname, believing it unfairly implied he was dominated by Berger. Soon after he was on the court, Berger assigned Blackmun to write the opinion in Roe. It was a major opportunity for Blackmun to prove his intellectual heft and display his constitutional prowess. According to Bob Woodward's book, The Brethren, Blackmun suffered from a profound sense of insecurity. From his first day at the court, Blackmun had felt unworthy, unqualified, unable to perform up to standard. He felt he could equal the chief and Thurgood Marshall, but not the others. He became increasingly withdrawn and professorial. He did not enjoy charting new paths for the law. He was still learning. The issues were too grave, the information too sparse. Each new question was barely answered, even tentatively, when two more questions appeared on the horizon. Blackmun knew that his colleagues were concerned about what they perceived as his indecisiveness. Blackmun also brought enormous respect for doctors to the court from his many years as counsel for the Mayo Clinic. He saw abortion laws as state meddling with a doctor's professional judgment. In Roe, Blackmun plunged himself into the history of abortion and even returned to the libraries of the Mayo Clinic to research the medical opinion. Blackmun had other influences working on him, most notably his wife. Nixon had been quite prescient about the effect of Blackmun's wife on his judicial role. While Blackmun was dithering over the opinion, Dorothy Blackmun told one of his pro-abortion rights clerks that she was doing everything she could to encourage her husband in that direction. "You and I are working on the same thing," she said, "me at home and you at work." Blackmun later claimed that she and his 3 daughters never tried to influence his decision. Other justices were also predisposed to dismantle the nation's abortion laws, including another Nixon appointee, Lewis Powell. As Bob Woodward noted, Powell came quickly to the conclusion that the Constitution did not provide meaningful guidance. The right to privacy was tenuous. At best, it was implied. If there was no way to find an answer in the Constitution, Powell felt he would just have to vote his gut. When he returned to Washington, he took one of his law clerks to lunch. The abortion laws, Powell confided, were atrocious. His would be a strong and unshakable vote to strike them. He needed only a rationale for his vote. Powell's vote, in other words, was not dictated by a serious effort to interpret the Constitution. Instead, he made a policy decision and then set out to justify it. Justice Potter Stewart was also in favor of striking down abortion laws. Although he had some misgivings, Stewart thought abortion reform was necessary for various policy reasons. As Stewart saw it, abortion was becoming one reasonable solution to population control. Poor people, in particular, were consistently victims of archaic and artificially complicated laws. Still, these were issues of the very sort that made Stewart uncomfortable. Precisely because of their political nature, the court should avoid them. But the state legislatures were always so far behind. Few seemed likely to amend their abortion laws. Much as Stewart disliked the courts being involved in this kind of controversy, this was perhaps an instance where it had to be involved. Blackmun acknowledged some of the policy issues at stake in the abortion debate, like overpopulation, in the introduction of his opinion. We forthwith acknowledge our awareness of the sensitive and emotional nature of the abortion controversy, of the vigorous opposing views, even among physicians, and of the deep and seemingly absolute convictions that the subject inspires. One's philosophy, one's experiences, one's exposure to the raw edges of human existence, one's religious training, one's attitudes toward life and family and their values, and the moral standards one establishes and seeks to observe are all likely to influence and to color one's thinking and conclusions on abortion. In addition, population growth, pollution, poverty, and racial overtones tend to complicate and not to simplify the problem. Nice speech, but it had nothing to do with the constitutional analysis of Roe. From this inauspicious beginning, Blackmun began a comprehensive, multi-page review of the history of abortion from the beginning of time to the present day. He led with the attitudes of the Persian Empire, the ancient Greeks, and the ancient Romans, and tried to divine the real meaning behind the Hippocratic Oath. He moved on to the old common law of England and examined Christian theology and the works of Catholic theologian Thomas Aquinas. From Europe, he proceeded to the history of abortion law in the individual states. Not stopping there, he outlined the positions of the American Medical Association since the 1800s, as well as the position of the American Public Health Association and the American Bar Association, as expressed in the ABA House of Delegates. Once the history lesson was completed, Blackmun sought to refute the various policy reasons given for America's abortion laws. Finally, Blackmun focused on his legal rationale in Roe. He began with a review of the right to privacy, writing in part, "The Constitution does not explicitly mention any right of privacy. In a line of decisions, however, the court has recognized that a right of personal privacy, or a guarantee of certain areas or zones of privacy, does exist under the Constitution. In varying contexts, the court or individual justices have indeed found at least the roots of that right in the First Amendment, in the Fourth and Fifth Amendments, in the penumbras of the Bill of Rights, in the Ninth Amendment, or in the concept of liberty guaranteed by the first section of the 14th Amendment. These decisions make it clear that only personal rights that can be deemed fundamental or implicit in the concept of ordered liberty are included in this guarantee of personal privacy. They also make it clear that the right has some extension to activities relating to marriage, procreation, contraception, family relationships, and child rearing and education." Blackmun felt that the right of privacy, wherever it comes from, includes the right to abortion. Do not look any further for legal argument amidst the voluminous opinion, because it does not exist. Perhaps the extensive historical analysis was included to compensate for the lack of legal analysis. But Blackmun went further, and the court followed. Not satisfied to strike down the Texas law, Blackmun began to write what seemed to be a new federal statute. According to Blackmun's opinion, a woman's right to abortion could only be abridged by a compelling state interest. In effect, Blackmun argued that there was an inverse relationship between a woman's interest and the state's interest that ranged across a spectrum from conception to birth. Therefore, the state's interest at conception was minimal, but increased as the pregnancy progressed, reaching its peak at the end of the pregnancy. A woman's interest, paramount at conception, began to give some ground to the state's interest in protecting the fetus as it matured toward being able to live outside of the mother. But Blackmun specifically declared that the unborn child was not a person under the 14th Amendment, and thus had no equal protection rights. Blackmun wrote that what really mattered was the unborn baby's viability outside the womb. A fetus capable of life outside the womb, Blackmun believed, was more deserving of protection than one in its earliest stages of development. He also shot down Texas's attempt to define life as beginning at conception, which, by adopting one theory of life, would have then allowed Texas to extend its interest to the earliest stage of pregnancy. Blackmun wrote, "We need not resolve the difficult question of when life begins. When those trained in the respective disciplines of medicine, philosophy, and theology are unable to arrive at any consensus, the judiciary, at this point in the development of man's knowledge, is not in a position to speculate as to the answer." Blackmun gave deference to medicine, philosophy, and theology from his own perspective, but not to the Constitution, the people, the states, or the other branches of the federal government. In truth, Blackmun did establish, at least for constitutional purposes, when life begins, by recognizing abortion as a constitutionally protected right to privacy. He did precisely what he lectured should not be done. Blackmun constructed a hyper-technical trimester analysis to break down the rights of the mother and the state. In the first trimester, the decision to abort must be left to the woman's physician. In the second trimester, the state may regulate abortion procedures to promote its interest in the mother's health. In the third trimester, in the interest of protecting the unborn child, the state can regulate and even ban abortion, except where, by medical judgment, it is necessary to preserve the mother's life or health. The trade-offs inherent in the trimester system smack of the bargaining and dealing that legislators engage in to pass a highway construction bill. It is no wonder that activists justify Roe on policy and not legal grounds. But since this policy decision was disguised as a constitutional pronouncement by the court, American law has been prevented from keeping up with rapid improvements in medical technology. Repeatedly, the court has shown no willingness to recognize an earlier concept of viability to limit the reach of the abortion right. Of course, from an analytical and logical point of view, a ban on abortion could have been upheld regardless of whether a fetus is protected by the 14th Amendment as a person. Americans are fined or imprisoned for destroying endangered wildlife or even wetlands, and these laws have been ruled constitutional. In any event, Blackmun's stated deference to medicine, in which a doctor can authorize or perform an abortion for the health of the mother, belies his third trimester framework. This point was driven home in 2000 in Stenberg versus Carhart, when the Supreme Court struck down a Nebraska law prohibiting partial birth abortion. Justice Stephen Breyer, in writing the majority opinion, stated, "We conclude that the law banning partial birth abortions violates the Constitution for two independent reasons. First, the law lacks any exception for the preservation of the health of the mother. Second, it imposes undue burden on a woman's ability to choose." Consequently, the Supreme Court upheld a particularly vicious method of performing an abortion. A court historian believes Blackmun's leftward drift from moderate to liberal jurist was a result of Roe. It was not just the criticism and the hate mail he received, but also thank you letters he received from women. Over time, he came to think he had done a great thing for women, and it made him much more attuned to the cause of protecting individual rights. Another way to describe Blackmun's shift is less charitable. He was moved and thereby seduced by public opinion in much the same way a politician is. There is evidence that Blackmun was particularly vulnerable to this type of lobbying. Chai Feldblum clerked for Blackmun during the term after he had issued his dissent in Bowers versus Hardwick, 1986, in which he argued that the right to privacy protected homosexual sodomy. His office was once again flooded with letters from across the country. "I believe he was radicalized by the response to the case," says Feldblum, now a professor of disability law at the Georgetown University Law Center in Washington, D.C. The hate mail told him that prejudice existed, and sodomy laws were part of the problem. The fan mail came from gay people who said things like, "I am gay, and your dissent meant so much to me. I'll never forget how much that meant to him." There is something truly absurd and frankly repugnant about a judge being swayed by fan mail. After Roe, Blackmun saw his role as championing a cause, not interpreting the Constitution. At the end of his career, he dramatically announced without a trace of irony that he was morally opposed to the death penalty. "From this day forward, I no longer shall tinker with the machinery of death," said the author of Roe, as if his ruling in Roe did not constitute a tinkering with the machinery of death. Blackmun continued to issue self-congratulatory, pompous, and maudlin statements about Roe's importance and vulnerability. If it goes down the drain, I'd still like to regard Roe versus Wade as a landmark in the progress of the emancipation of women, he said. In 1992, with a presidential election looming, Blackmun made a dramatic call, within a Supreme Court opinion, to the supporters of abortion. He piously intoned, "And I fear for the darkness as 4 justices anxiously await the single vote necessary to extinguish the light." Yet Roe has survived, despite attempts to overturn it. Blackmun's personal papers reveal that Justice Anthony Kennedy made a last-moment switch and abandoned one such attempt in Planned Parenthood versus Casey, decided in 1992, thereby providing the crucial 5th vote to uphold Roe. There are some interesting parallels between Kennedy and Blackmun. Both were their president's 3rd choice for the Supreme Court and were considered competent but not exceptional when vetted by the White House. And, like Blackmun, Kennedy is going through a leftward evolution on the court. Kennedy, Justice Sandra Day O'Connor, and Justice David Souter issued jointly the majority opinion of the court in Casey, a very unusual move. The court allowed certain restrictions on abortion, but left the essential holding in Roe intact. The 3 justices began by stating the court's obligations. Some of us as individuals find abortion offensive to our most basic principles of morality, but that cannot control our decision. Our obligation is to define the liberty of all, not to mandate our own moral code. The underlying constitutional issue is whether the state can resolve these philosophic questions in such a definitive way that a woman lacks all choice in the matter, except perhaps in those rare circumstances in which the pregnancy is itself a danger to her own life or health, or is the result of rape or incest. Of course, defining and establishing parameters for liberty and life do involve moral questions. Justice Kennedy, like Justices Douglas, Brennan, and Blackmun before him, delivered his own speech on the right to privacy. These matters, involving the most intimate and personal choices a person may make in a lifetime, choices central to personal dignity and autonomy, are central to the liberty protected by the 14th Amendment. At the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life. Beliefs about these matters could not define the attributes of personhood were they formed under compulsion of the state. These words have been ridiculed by many, including Justice Antonin Scalia, as the sweet mystery of life passage. Scalia later wrote, in a different case, "I have never heard of a law that attempted to restrict one's right to define certain concepts, and if the passage calls into question the government's power to regulate actions based on one's self-defined concept of existence, etc., it is the passage that ate the rule of law." The right to define one's concept of the universe is the modern incarnation of the emanations from penumbras that allegedly provided a right to privacy. It is just another meaningless, pseudo-sophisticated phrase by which justices evade our constitutional framework and impose their personal views on the rest of us. Almost 10 years later, Kennedy, in concluding that homosexual sodomy is a constitutional right in Lawrence versus Texas, declared, "Liberty presumes an autonomy of self that includes freedom of thought, belief, expression, and certain intimate conduct. Liberty also presumes, indeed requires, something our courts lack: fidelity to the rule of law and respect for the legislative branch of government, where controversial issues can be resolved through the elected representatives of the people, rather than a handful of unelected justices." There are no more emotional and controversial moral and societal issues than those related to privacy, personal behavior, and liberty. And it's for this reason that public influence on government policy, exercised through the respective branches of government, is so crucial to ensuring the legitimate and proper functioning of a constitutional republic. To be true to its constitutional role, the Supreme Court should refuse to be drawn into making public policy, and it should strike down legislation only when a clear constitutional violation exists. When judicial activists resort to various inventions and theories to impose their personal views on privacy and liberty, they jeopardize the legitimacy of the judiciary as an institution and undermine the role of the other branches of government.